So I will be giving an overview of the human rights from a patient perspective by examining what is the role of the current EU privacy framework. And namely, I will be focusing on GDPR and the emerging technologies when balancing the patient's rights from the one hand of health and privacy and the right to research and innovation from the other hand. So my presentation is separated in three different categories. The first will be examining the human rights, and the second, the technologies. The third will be focusing on GDPR aspects. So unarguably, health consists one of the fundamental rights of every human being, and this is not something new. It's something that can be founded and stated already back in 1946 at the WHO Constitution, where it said that the highest attainable standard of health is one of the fundamental rights of every human being. However, and despite such declarations, the human rights violations in healthcare contexts is something that is noticed, and it's also reported and documented in our everyday. We can see such events and documented by government bodies, by NGOs, the United Nations, and it's a great variety of violations. Regardless, gender, race discrimination, social exclusion, especially of minorities, and so on. Specifically, when it comes to patient care and to the violation of rights-related data protection, the specific violations have to do with the information, the right to know what the illness is and what the patient suffers from, what are the causes. In numerous occasions and numerous settings, we see that this information is not provided to the patients. Other violations have to do with the access to the records and to the reports of the patients. These, in numerous cases, for example, are not accessed by the patients. Even when it comes to the informed consent, it's not just a matter of having the best quality of treatment, but also having that in an informed way, respecting the patient's will. And we see violations also when it comes to the information part of the informed consent. And last but not least, the states in several cases have incidents of violations on behalf of the state towards the medical secrecy of doctors. So what is the way out from these violations? Despite the fact that we observe them and we see them, the thing is that we need to also to provide some solutions. And the tangible tools out there that nations have found are first of all, legal instruments. And these also include the soft law and ethical guidelines. Of course, the training of the healthcare providers is another very important tool that we have in our hands, and the education of the society and the awareness of the society as a whole, of the patients, as we saw before from Tamara, their rights and their and what they can really stand for. On an international level, the instruments that we have for both rights, for both the privacy right and the health right, can be found already from the Universal Declaration of Human Rights back in 1948. So we have the right to privacy, Article 12, and the right to seek and receive information, and both rights, Article 19. Both rights are directly applicable in healthcare. And in fact, it is also something that we need to underline, that this is a dual loyalty right for the healthcare providers, since they have a simultaneous right to inform their patients and at the same time keep confidential such information from the one hand, but also they have an obligation towards the state to disclose health information under specific circumstances. The European Convention also, in the Article 8, echoes what the Article 12 of the UN Declaration says, and also provides specifically that everyone has the right to respect for his private life. And on an international law instrument, we should not neglect also the Oviedo Convention. the OVO, the Convention of the Council of Europe, with all the additional protocols, and namely the Articles 1, 3, and 10, which reflect the informational rights and the equitable access to health. On a EU level, when trying to map out what is going on a legal level, the most important document is, of course, the EU Charter of Fundamental Rights. And here again, we can see that both the right to information as well as the right to health has relevant provisions, and namely Article 8 is referring to the right to protection of personal data of the people, and this of course applies to patients. And Article 35 refers to the right to health protection as the right of access to preventive health care and the right to benefit from medical treatment under the conditions established by national laws and practices, and specifies that the union must be the union must guarantee a high level of protection of human health. So there is a very strong connection between personal data and the importance for healthcare. And we can see that even more evident when we see the role of the emerging technologies that they play in the contemporary healthcare setting. In fact, in the era of personalized medicine that we're now experiencing firsthand, we can see that healthcare and research are in fact the two sides of the same coin, in the sense that data circulation from patients to research and vice versa is vital for ensuring treatment, safety, and research efficiency. And I have only indicated three of the reasons that I found very important for this. First of all, data are important for scientific innovations, and often, for example, novel biomarkers emerge after a study has ended. And then reanalysis of existing data is crucial to bring new knowledge into personalized treatments. And this is something that we know from years now of practice. And also the reproducibility of discoveries. This also needs personal data. The validation of scientific results by independent experts. This again needs access to personal data. In order for the above goals to be met, however, this requires that flexible rules and flexible laws are applied, and that flexibility is not seen as a barrier to medical research. Therefore, room for interpretation needs to be left. It's a key element for innovation to be able to develop. And when doing the balancing test of the individual's protection from unauthorized access to the data and the right to research as both a right of the researchers and an obligation of the state, a careful assessment needs to be in place. Another requirement is what we heard before also for the systematic engagement of all the stakeholders. It goes without saying that this is a collaborative issue. Patients, research, industry, and academia need to collaborate. And one of the lessons that SIENNA provides us is that this systematic engagement is indeed vital. And of course, the early access of patients to health innovations, the timing of access to health innovations is one of the most important requirements. So it has been made clear from all the above that data plays a very crucial role in the promotion of research and innovation and in ameliorating the healthcare quality. However, there are many questions which arise, and we have to see that when we talk about data and we talk about data in use for the patient through the innovation path, we need valuable data. It's not just any kind of data. We need data that are of sufficient quality, that are standardized, data which are interoperable and people can access their rights, their subject rights, like portability, for example, data that can be reused. And this needs to ensure also the privacy protection and avoidance of privacy breaches in all settings in all contexts, from healthcare to research. And to that extent, there are numbers of ethical principles like integrity and like autonomy that need to be respected, and transparency. And patients should not be treated as data pools. Data are in fact very important for innovation, but autonomy is the key, and people always need to be respected. This is something reflected in all the above mentioned international legal instruments that I referred above, and also to the EU legal instruments that I referred above. And they need to be seen as means for the innovation, not as means of the innovation, but as end themselves. That requires a never-ending balancing and an ethics and privacy assessment test. So the privacy that we are very familiar to nowadays due to GDPR and the privacy by design also extends to privacy, to an ethics by design model that needs to be followed. To that extent, there are many tools out there. I just indicatively say here some RRI tools for responsible research, which try to make more tangible this assessment, this balancing test that researchers need to have in place in order to do responsible research and at the end of the day, help patients. And of course, it was also mentioned before about big data. And data, as we said, plays a very important role. But in our days, things get more complicated as data keep on circulating from device to device with IoT and emerging technologies. The digital footprint out there, namely what we all know as big data, is just too big, which means that it brings new questions, and it brings new, as it constantly expands, new questions which arise in the innovation context, such as who collects our data and for what purposes and why, and who benefits, and what do I get back as a data subject, and for how long is my data kept? How can I access them and exercise my rights? How can the data be reused from research to healthcare and vice versa? And how can we as data subjects be in control of the data life cycle? This is a very big question. And if it's possible, if there is no interoperability among technical systems of various stakeholders, how can we do that? How can we achieve all the above? It gets even more complex when we talk about the emerging technologies. Indicatively, I refer to AI, for example. And there are companies like IBM, for example, who do provide services for AI in healthcare. But we have to admit that it gets more complex, even though we have some tools. And this is what we have. In fact, this is just what we have, legal and ethical tools that we use already to assess these new challenges. And we have to move forward with the tools that we already have. And currently in Europe, we see that the research landscape remains fragmented. Possible solutions, perhaps wider collaboration, can this be done? And if yes, under which circumstances? A pan-European research code of conduct. We know BBMRI, Eric, is currently working on the development of such a code. Now, SIENNA is working for an ethics code of conduct. We know the role of the DG Health, for example, and the EHDS initiative. I have here the link to a report which talks about it's exploring the implementation on a national level of GDPR in regards to health data. Another perhaps is a question which arises about the infrastructures existing out there, the already existing infrastructures such as 1MG, for example. What can they offer back? And at the end of the day, what is the role of GDPR? Could it facilitate the secondary use of data, this, let's say, travel of data between healthcare and research? And we have also conducted with two colleagues who were also in CRB in Uppsala, Santos Luckenberger and Jane Rachel, a book here which was funded, the open access of which was funded by BBMRI Eric. And we tried to scrutinize how GDPR, in fact, affected biobanking. But this goes beyond also biobanking, goes also to biomedical research. And in the comparative chapter, we saw that this landscape is indeed fragmented. And so what is the solution? This is the next question. Is there a solution? To give a solution, we have to go back and see what was the situation before GDPR came in place. So before GDPR came in place, we had the Directive 95/46, where the secondary process for research proposals were permissible only if the member states permitted it. Now, under GDPR, this has been reversed due to the Article 5.1b. So the further processing is, in fact, something that can be done if the safeguards of Article 89 are in place, which is a huge change for secondary use data. And this is also the same, we can see this also in the clinical trial regulation with the Article 28 and the EDPB opinion, where it's stated with the presumption of compatibility, Article 5.1b GDPR, that it should not be excluded that given the safeguards are in place, the Article 89 safeguards are in place, that the clinical trial data can be used for the scientific purposes outside that means the clinical trial protocol. So it is pretty clear that the proof is in the safeguards. It all goes bound when we have to assess and when we have to do this balancing test with the privacy rights to Article 89 in the safeguards. But this vary on a national level from country to country, and it complicates things even more. It varies from technical measures such as pseudonymization or encryption to training of employees or to informed consent. As EDPB also stated, informed consent can be seen as an additional safeguard in the context of research, to professional standards, to IRB regs approvals / opinions. And this is quite problematic when we have IRB or reg approvals, because it's a completely different thing to have an opinion in your hands and a completely other thing to have an approval. So all these challenges that these safeguards bring, including some of these that I refer here, such as, are they data experts on board? Do they have patients? Do they have access to the decision of the regs? Are they incidental finding policies? What is the privacy by design? This is a very, very, very vague concept of legitimate interest, and how is this applied in the research context? And also, what about the data of individuals which enter the EU? We know about the GDPR is applied to the exported data of the EU citizens. What about vice versa, the data coming in the EU? So there are many, many challenges, even if we try to put in place the safeguards. I would like to leave with the conclusion that as I said before, we have numerous legal instruments in our hands, and the non-stop balancing test needs to be assessed in order to support innovation while respecting at the same time the patient's privacy and health. As the situation is even more complex now with AI and the digital footprint and all the new challenges, we don't have any other solution but to use the existing tools that are there to safeguard. And when it comes specifically to personal data protection, we have identified the fragmentation that GDPR broke in the national legislations, but it remains, what we have in our hands now remains to be the safeguards. So the best tool that we have to use to protect the above mentioned rights of health and privacy for secondary use remains the up-to-date safeguards and the respect to the existing safeguards, namely legal and ethical, of course.